We left off in the last video looking at the parole evidence rule. What happens when you have a signed written agreement and you try and get a verbal statement in? And just to recap, the parole evidence rule says, well, if this is the whole of the agreement, you should have written it down. You can't get verbal statements in. Now, sometimes this next rule can be a little confusing to many students, but it's dealing with a different issue. It sounds the same, but it's not. This rule, what we're dealing with is we have the written agreement and there's a term in there. It's not about getting something in, it's if the term is in the document. Now, if the statement is written in the document, in the contract, it's in. It doesn't matter if you haven't read it. It doesn't matter if it's in small print, right? You should read the contract because what is in there is a term of the contract. And Lestrange and Graucob is our authority for that. So hopefully that's fairly clear. When parties reduce their contract to writing, so when you've got this document that you've written and the contract is signed, that means it's very clear that both parties have read and understand what's in it. There's no evidence issue. Then what is in that document, the terms that are written in that document, form part of the contract, even if one of the parties actually has not read the written contract. And that's what the judge is saying. It's immaterial whether or not you've read it. It's irrelevant that the plaintiff did not read or hear of those terms in the sales document. Okay, so we've said that if we've got this signed written document that's the whole of the agreement, verbal statements can't go in. We've also seen that what is written in there is in. But what about where you've just got verbal exchanges as part of the contract? Or maybe you've got an email, you've got something in writing, or an incomplete written document. What becomes a term in those situations? Let's have a think about the problem a little bit more formally. So we know that sometimes agreements can be made verbally or orally, or they can be an exchange of emails, letters, or other forms of writing on a napkin, even a partially drafted contract. In these circumstances, we need to be able to work out which statements are terms and form an obligation on the parties, and which are simply part of the negotiation process and aren't a binding obligation. In terms of the language we're using, we need to distinguish between terms, which have an obligation, and non-contractual representations, which do not. So someone who makes a representation during negotiations but doesn't intend it to become a term, that's a representation. And they aren't part of the contract, even if they're breached. And the classic test for this is set out in Dick Bentley Productions. So Dick Bentley Productions involves a company, Dick Bentley Productions, wanting to buy a car. Guess what kind of car? A Bentley. Okay, so Dick wants to buy this car and he contacts a European noble. I think the noble was actually a count somewhere in continental Europe who has a Bentley for sale. And they have this exchange, including some writing and telephone calls. And as part of the telephone calls, he's obviously asking him, oh, how's the car, etc. What's the engine like? And the count says it runs beautifully. It's a fantastic car. You'll love it. The engine is really good. Okay, can you guess what's going to happen? Dick gets the car. And what do you think about the engine? Exactly, right? Got to replace the whole engine. The engine is no good. So then the question becomes, look, there was this documentary exchange, etc., but there was also this telephone call where the purchaser was assured that the engine was in good working condition, and it wasn't. Was that verbal statement a term of the contract? Now, we have to be clear, the exchange of documentation was not the whole of the agreement, right? It was just some of the terms, like the price and things like that, were exchanged via writing. And so now we've got to work out whether this statement is a term. And the court in this case formulate a test based on three factors. Those three factors are time lapse between the statement and the formation of the contract. How close to agreement was the statement made? The closer to the point of agreement the statement is made, the more likely it's a term. The further away, the less likely it's a term. Second, how important was that statement? How important was it that the engine was in good condition? that has a different level of importance to whether the car will be delivered washed. Can you understand that? So the more important a term is to one of the parties, then the more likely it's a term of the contract. The third factor is, do any of the parties have special skill or knowledge about the term? And in this particular instance, we know that one party owns the car and runs the car and knows whether the engine works, and the other party doesn't and can't inspect it because they're in a different country. So one party has special knowledge. Okay. Take the three factors together. The statement was made near the point of contracting. Whether the engine was in good condition or not was a very important term of the contract, and one party had special knowledge about that. Because of those three factors together, it's not one or the other, or it's like you look at the three and you go, based upon that combination of factors, it's a term. And so in this instance, it was a term of the contract. And therefore it was a breach when the engine wasn't in good condition. For those who are super interested in this topic, you can look up Oscar Chess about a case that goes the other way. So with those three rules, the parole evidence rule, the rule in Lestrange about what's written in a contract is in the contract, and the Dick Bentley test, we can actually, for the purposes of our subject, work out whether a statement is a term or a representation. And to do so, we've put together this little flowchart which gives you an abstracted view, a somewhat simplified view, but a very, very solid approach to working out whether something's a term or a representation. So the first question you should ask yourself, is there a signed written document that's the whole of the agreement? Okay, if you've got a signed written document that's the whole of the agreement, then you've got to ask yourself, is the contested statement the thing, is it a term or a representation, the thing that we're arguing about? Is that statement in the agreement? If that statement is in a signed written document that's the whole of the agreement, it's a term. Lestrange tells us that. If the statement isn't in the signed written whole of agreement, then the parole evidence rule applies and it's not a term. Okay, so whether you have this signed written whole agreement is super important, you can see, because the only question then becomes, is it in that statement? Is it in that written document? It'll be a term. Or if it's not, it won't. The more difficult issues arise where we don't have a signed written document that is the whole of the agreement. Well, then we've got to say, is there any written documentation? Are there any emails? Is there a partially written document? Is there a napkin with something written on it? If the answer is yes, and if that statement is in that agreement, right, if that statement is in the written document, then Lestrange says it's a term of the contract because it's written in. So, again, the importance of getting the terms that you're after into written documents comes through clearly. What happens if the statement isn't in that written document? That's when we apply the Dick Bentley test. How close to the point of agreement was the statement made? How important was the statement? And did one party have special skill or knowledge? If it meets the Dick Bentley test, then that verbal statement can be part of the contract. If it doesn't, it's not part of the contract. So, go back again. We've got a signed written document, whole of the agreement. No. Is there a written document? Yes. Was the statement in there? No. Then we apply Dick Bentley. If the answer to Dick Bentley is yes, it's a term. If the answer is no, it's not a term. And then finally, is there a written document? No. So this means we've got an entirely oral contract or verbal contract. If we have a verbal contract, then we just apply the Dick Bentley test. If it meets the Dick Bentley test, time lapse, importance, special skill or knowledge of one of the parties. If it meets Dick Bentley, it's a term of the contract. If it doesn't, it's not a term of the contract. So hopefully that gives you some sense of how those three rules, the parole evidence rule, the rule in Lestrange, and the Dick Bentley test, fit together to help you work out, based upon a scenario, whether a statement is a term of the contract or not. Some of those rules seem quite strict. For instance, the parole evidence rule. If someone kind of really induces you with a statement to get in there and then relies on a signed written contract, not honour that particular promise that they've made because of the parole evidence rule, it can seem unfair. Now, just remember, we're dealing with common law contract law here, case-based contract law. There's whole other areas of law that might provide a remedy for you. There is one under contract law that I'm going to go through. But most likely, your solution to your problem is going to lie perhaps in consumer law for misleading and deceptive conduct, or maybe even as a vitiating factor under misrepresentation, something we don't spend a lot of time at in this course. So always remember, there are these other avenues if people are dodgy during negotiation. So don't be dodgy thinking you're going to get out of the problem because you know about the parole evidence rule. There are these other things we haven't covered that could cause you problems. One of the things that could cause you problem is a breach of collateral contract. And this is a common law way of approaching the problem of a statement that can't be included into the written document due to the parole evidence rule. So a collateral contract involves a secondary contract. This is the most important thing to understand. So what we have is the main contract. And remember, this is a whole of agreement in writing. Now, because it's a whole of agreement, the parole evidence rule applies. So if someone makes a statement over here to get you to enter this contract, and then you have a whole agreement that you sign, and this statement isn't in there, if it isn't in there, right, then we know it can't form part of the main contract because of the parole evidence rule. However, what the courts can say is that there was actually two contracts, the main contract and then a collateral contract. And this collateral contract is a verbal contract where one party makes the statement, that's their consideration, and the other party enters the main contract as their consideration. So there's a second oral contract going on here, and the party breaches this collateral contract. Now, if I was you, I'd be sitting there going, my goodness, what the heck? Why did you just do all of that work about the parole evidence rule and then say, but you get over the parole evidence rule with a collateral contract, a second contract over here? Okay. The key thing is remedy, right? This collateral contract, breaching this secondary contract, does provide you damages for that breach of contract, negotiating power because now you have this damages issue. However, there's no breach of the main contract. So if you actually want to get out of the main contract, you can't. This is the reason it matters. You always want to try and get the term into the main contract because then it's probably going to be a condition which will allow you to terminate. You can't terminate for a breach of collateral contract. All it can give you is some negotiating power to get the other party to release you from your obligations, okay? So there's a big difference in what the outcome might be, and that's why it matters. And as I've mentioned before, we don't examine implied terms in any detail in the subject, but just remember courts can imply or read terms into a contract for various reasons. The way things are normally conducted in that kind of business, the way that the parties have dealt with together, sometimes for common sense, etc. We also have the case where legislation can insert terms into a contract, particularly the Australian consumer law inserts a lot of terms into consumer contracts. Having said that, it's not easy to get a term implied unless it's one of those statutory or common law implied terms. If you're trying to get a term implied because the parties agreed but just didn't write it down, it's actually quite a difficult test. And I'll just leave you with that key understanding. It's difficult to get implied terms in unless they're required by our common law, by the courts, or statute. Whew. Okay, so now we should be able to differentiate between whether a statement made during a negotiation or as part of the negotiation process has become an obligation or not, whether it's a term or a representation. Next video, we're going to deal with a very special type of term, disclaimers.